Very good evening, everyone. We start tonight our webinar number 5 of our business law, business English webinar series with our American virtual English specialist, Alexandra Dorche, an attorney from New York. And today we have a very exciting topic, which is mergers and acquisitions and due diligence. So very specific, very interesting, very broad topic. And I would like to remind you that during our webinar, which is live right now, you are very welcome to ask questions that you can write in YouTube comments on our YouTube channel. And you can also write them in our Telegram channel. And also, we are going to ask you questions. Alexandra is going to ask you questions, and you are very welcome to share your answers, your opinion, and we're very glad to start. So, Alexandra, very good evening, and hi from St. Petersburg to you.
Hi, guys. Hi, Russia. How are you? Hope everyone is doing well. I am putting it's mergers and acquisitions. Sophia says it's very exciting. It's a lot of work, so we're going to get to it. But I want to give the joining instructions. So in case we have a poll, hopefully I'll give you a couple of seconds to, copy the QR code, and we could move from there.
Yes, and just wanted to remind you that also when we have the polls, if they work, there will be also the joining instruction on top of the page, and we will see and we will remind you how it works.
All right, guys. So let's start mergers and acquisitions. Okay. So when we're dealing with mergers and acquisitions, sorry, guys. Let me put this on a slideshow. So when we're dealing with mergers and acquisitions, we're dealing with antitrust law. In Europe, they're called competition law. So antitrust laws are regulations that encourage competition by limiting the market power of any particular firm. So you don't want any one company having too much power. This often involves ensuring that mergers and acquisitions don't overly concentrate market power or form monopolies, as well as breaking up firms that have become monopolies. So basically, the goal of antitrust laws is that you don't want anyone to be too much powerful, and you don't want a monopoly. You don't want one person dominating a market and getting most of the money or setting the rules for the market. Sorry for this, guys. Okay. Again, I may be referring to my notes. So if I stop, I'm referring to my notes. And sometimes you may hear Sophia say hands. That's because I'm a New Yorker. I talk with my hands, so I'll put my hands down. Okay, so antitrust law continued. Antitrust laws were designed to protect and promote competition within all sectors of the economy. So it's to promote competition. The big guy can compete with the little guy, or the big guy can compete with the big guy, and the little guy can compete with the little guy. It's all about competition. The Sherman Act, the Federal Trade Commission Act, and the Clayton Act are 3 pivotal laws in the history of antitrust regulation. Today, the Federal Trade Commission, sometimes in conjunction with the U.S. Department of Justice, is tasked with enforcing federal antitrust law, but primarily it's the Federal Trade Commission. Department of Justice, or the DOJ. The DOJ provides legal services to the national government and its functionaries, including government-owned and controlled corporations and their subsidiaries, to ensure that all actions are within the context of the rule of law. So the DOJ is the U.S.'s basically law firm. So anything that has to do with the U.S. or anything that, if the government is being sued, the federal government is being sued, the DOJ is involved in it. The Federal Trade Commission, the FTC, enforces federal consumer protection laws that prevent fraud, deception, and unfair business practices. The commission also enforces federal antitrust laws that prohibit anti-competitive mergers and other business practices that could lead to higher prices, fewer choices, or less innovation. Again, it's about one person not controlling the market. Because as they say, one person control the market, they can set the prices, you have fewer choices, and, who cares? We'll give them anything, less innovation. One thing, in terms of the Federal Trade Commission, one thing that they do, fraud and deception, unfair business practices, they go after people who are involved in fraud or deception. One form of deception or fraud, I don't know if you guys in Russia have this, telemarketers. In the United
Yes.
States, we have okay, so we have telemarketers. So you can be on a list so telemarketers don't call you. But one thing telemarketers love to do, a lot of them, is that they make believe they're telemarketers. They call older people and they tell older people, senior citizens, about, oh, you've won some money, but in order to get the money, you have to send us some money, whatever. So you have a lot of older people that have lost a lot of money wiring money because they think they're going to get more money. So it's cases like that the FTC takes care of, and a lot of other kinds of cases. Okay, so poll open. DOJ and FTC, what do they do?
Okay, everyone. So if you look at the slide, you can see that you need to go to vvox.app and you need to fill in the gaps, the ID number. So you can see it over there, 164. So, and you can just answer the poll. Or if you want to, you can answer also in YouTube chat box. And you are very welcome to do it because someone might have issues with joining the vVox. So both options are fine, absolutely. Although, of course, for us, it's interesting to see visually how it works on vVox. So it's a special website where you can answer your the questions that Alexandra gives you. So, and it works, Alexandra. I'm even afraid to breathe on the screen. So, and we're trying to see how it works. And also we do have some answers on YouTube, and you are also, of course, very welcome to do it. We need some time to give to our viewers to answer, and then we'll do.
Yeah, well, if a couple of more people to answer, then we'll go, because we have a lot of information to go through today.
So exciting. I was right. It is exciting. And once you join vVox, you can basically stay there because there will be more polls to answer. So you don't have to shut down the poll. And when there is another vote, you can just continue.
All right, guys. So I'm going to go. We're at 9:11. Like I said, we have a lot of info to cover today, so I'm not going to stay too long on this. Okay. All right. Very good. Most everybody said the last one. Yeah. I think 50. People put 50-50. Oh, 0 for the first one, 50-50. Okay, so it's the last one. Okay, so DOJ is the U.S.'s law firm. It provides legal services to the national government, makes sure that all, make sure. Let me put this, because like I said, I'm not reading it. I'm gonna go and make sure that all actions comply with rule of law. The FTC enforces federal consumer protection laws to prevent fraud, deception, and unfair business practices. So if you chose the last one, you're correct. The other one, no, because the other one says the FTC provides only the national government with enforcement of trade and commercial activities. No, it's everybody. The FTC goes out after everybody. All right. Thank you for joining. And thank you for doing this. The Sherman Antitrust Act. Okay. Approved July 2nd, 1890. The Sherman Antitrust Act was the first federal act that outlawed monopolistic business practices. The Sherman Antitrust Act is a law the U.S. Congress passed to prohibit trusts, monopolies, and cartels. Anybody can tell me what a cartel is? Anybody know what a cartel is?
We'll need to give them time. Yes, everyone. Yeah. So if you would write while we're discussing what cartel is, and when we will get back to, for this answer, we would be happy if someone can share. So we'll give some time, because we remember that there is a small delay in like 20 seconds.
So the purpose was to promote economic fairness and competitiveness, and to regulate interstate commerce. Again, we keep on seeing the word competitive. They want the market to be competitive. The act signaled an important shift in American regulatory strategy towards business and markets. So this is 1890. Okay.
And it's still in force.
Yeah, well, we'll get to that. The Sherman Act is also outlawed contracts, conspiracies, and other business practices that restrain trade and created monopolies within industries. Okay, the Sherman Act was amended by the Clayton Antitrust Act in 1914, which addressed specific practices that the Sherman Act did not ban. So the Clayton Act amended the Sherman Act. So basically, we looked at the Clayton Act now, but we have other acts coming. So did anybody have the answer for cartel?
Oh, yes, we have got two answers. So Daria and Pavel wrote that cartel is a group of companies or corporations that conduct business in common following the same policies. Or a group, Marusia also says that a group of companies that agree to raise their prices and they are not in competition with each other. So together.
Okay, so it's okay. The first one is more online. The cartel, a group of people, they're in business together, or it's one giant company that sets the standard and sets the price. So a lot of times when they're talking about drug cartels, you're talking about drug dealers, you're talking about cartels. So what happens is you have a group that they set the price, they make it usually really high, and no one else can get in. So they sell at a high price, they have the monopoly, and no one else can get in. It's very, very difficult for people to get in. So what happens if there's a cartel, if there's a war, a problem, you try to take over a cartel's territory, what happens? There's a war, they shoot you, there's problems. So that's what a cartel is. Usually a cartel is not, cartels are not usually legal entities. So that's what a cartel is. So I wanted the difference between a cartel and a company. Okay. The Federal Trade Commission Act of 1914 is the United States federal law which established the Federal Trade Commission. So this is the act that established the Federal Trade Commission, FTC. The act was signed into law by U.S. President Woodrow Wilson in 1914 and outlaws unfair methods of competition and unfair acts or practices that affect commerce. Again, we keep on seeing competition. The Clayton Antitrust Act is a piece of legislation passed by the U.S. Congress and signed into law in 1914 that defines unethical business practices such as price fixing and monopolies and upholds various rights of labor. Okay. Price fixing. When we say price fixing, I'm talking about an agreement among competitors to raise, lower, maintain, or stabilize prices or price levels. So you have a group of people, say you have, this happens in a lot of markets. You have people in a market and you say, okay, well, let's fix the price. Everybody's going to sell for $8. We're going to sell this item for $8. Okay. So if somebody wants to sell it for $10 or $8.50, they're probably not going to get the business because everybody else is selling it for $8. They can get it for cheaper. So that's price fixing. And why is it a problem? Because it limits competition. We don't want competition limited. The Clayton Antitrust Act of 1914 continues to regulate U.S. business practices today. So remember, the Clayton Antitrust Act replaced the Sherman Act. It's intended to strengthen early antitrust legislation. The act prohibits anti-competitive mergers, predatory and discriminatory pricing, and other forms of unethical corporate behavior. When I say predatory pricing, predatory pricing, I don't want to stop the lesson. Let me explain when I say predatory pricing. So predatory pricing is that you have a certain group of people and you charge them much more than you would the average person because they don't have money. A good example of this is payday loans. I don't know if Russia has payday loans. Sophia, have you ever heard of payday loans?
Well, I just think we might have them if you can explain what exactly it is, because we might call them differently.
Is like they lend you up to maybe $400 or $500 before you get your check. So say, for instance, for some reason you run out of money in the middle of the month and you need money to meet your expenses, but the interest rates are like 30%.
Yes, we have them. We call them like micro loans or something like this.
Yeah, they're really hot, but they're illegal now because they're predatory. Why are they predatory? Because they're going after people who don't have money. So you already don't have money, and now you have a loan, and you're paying 30 or 40 or 25% interest on the money that you borrow. So it's always difficult. It's always difficult for people to pay them back. So that's an example of a predatory business establishment. It goes after a particular person and abuses that person because of their age, because of their race, because of their ethnic, affiliation. The act also protects individuals by allowing lawsuits against companies and holding the rights of labor to organize and protest peacefully. So labor organization is very, very important in the United States. Unions are large. I don't know if you read the US news, but a lot of companies have been going on strike, teachers, nurses, actors. Writers. Yeah, so that's very big. So this act allows laborers to organize and protest peacefully. The law is jointly enforced by the FTC and the DOJ. So both of them enforce it. Okay. Which was the first antitrust legislation?
And once again, so those of you who have joined VVox, you can stay there and vote. What is great about VVox, we like it, and we try to implement it so many times, poor Alexandra. So it's because it's anonymous. So we don't know who votes and how, so which is great. So you feel safe. But if you are brave enough, you may always write in YouTube. And we just wanted to remind you that our purpose here is to study. So, and we're very happy that we are with Alexandra, who gives us this information, the insight, and we can feel safe and practice together. And even if we make mistakes, that's fine. Absolutely. We're studying and just revising. So
we're at 9 to 10. Let me give the results. Let's see.
And there is also Pavel and some others who answer that it's 3.
Yeah, sure. Everybody got that right. 100%. Great. I would have never got that. Okay, so now we're going to start with mergers and acquisition, M&A. The Clayton Act gives the FTC the authority to review mergers and acquisitions. So a lot of times when somebody's merging or acquiring, they have to have FTC approval. This is done to decide whether the merger or acquisition would substantially lessen competition, again, or create a monopoly. If the FTC determines that a merger or acquisition would be anti-competitive, the FTC can disallow the companies from combining. So if they would have anti-competitive effects, the FTC can disallow the companies. So they look at the deal, they do their research, and they decide, okay, well, you know what I mean? You're trying to merge here. If you merge or if you acquire this company, you're going to have 51% or 55% of the business in the whole city, in the whole state, in the whole country. We don't think that's fair, so we're not going to let it go. And then there's litigation, okay? What is a merger? A merger is an agreement that unites 2 existing companies into 1 new company. There are several types of mergers and also several reasons why companies complete mergers. So A plus B equals C. So company A and company B create company C. Mergers and acquisitions are commonly done to expand a company's reach, expand into new segments, or gain market share. All of these are done to increase shareholder value. Who are shareholders? Anybody? One person. What's a shareholder?
Yeah, we'll just need to ask. So everyone? Who's a shareholder? So anyone. Yeah, it takes time a little bit. So we'll get back to it. Yeah.
So often during a merger, companies have a no-shop clause to prevent purchases or mergers by additional companies. So basically, if I'm trying to merge with a company, I have a no shop clause. I mean, I'm in the process of a merger right now, so I can't talk to you. You know, if it falls through, I'll get back to you. Okay. Oh, wow.
And we do have, we have got a couple of answers about the shareholder. Daria says owner of the shares, and Marusia says someone who owns shares of a company.
Yeah, they own shares of the company, which means they're the owners of the company. You know what I mean? They're the profit makers. So you want to give your shareholders, the goal of having shares is to make profit. If I buy shares in a company, it's to make money. So you expand anything to make your shareholders happy. You want to make them profit. Very important. The 5 major types of mergers are conglomerate, congeneric, market extension, horizontal, and vertical. So we're going to go through them. Conglomerate merger. This is a merger between 2 or more companies engaged in unrelated business activity. The firms may operate in different industries or in different geographical regions. Okay, so companies with no overlapping factors will only merge if it makes sense from a shareholder wealth perspective. Here it is again, you want to give your shareholders money. That is, if the companies can create synergy, which includes enhancing value, performance, and cost savings. Example, Walt Disney Company and American Broadcasting Company, they merged. Okay, so Walt Disney's what? you go there for rides. It's a family place. You go there for rides, for food, whatever. It has nothing to do. ABC is a what you may call it, a television station. So Walt Disney merged with ABC. So enhancing value, performance, and cost of savings. So I don't know in terms of how that would work out in terms of if Walt Disney's make a lot of movies. So maybe because ABC or American Broadcasting Company is a television station, they work in order to make the deals, in order to make for the television shows or any form of entertainment. That's the only way I could see that working, but I'm sure there's another reason. Okay. A congeneric merger is also known as a product extension merger. In this type, it is a combining of two or more companies that operate in the same market or sector with overlapping factors such as technology, marketing, production processes, and research and development. A product extension merger is achieved when a product line from one company is added to an existing product line of another company. So, okay, hold on. Ooh. Okay, continued. I sell insurance to space travelers, okay? I merge with another company that sells car insurance, health insurance, homeowners insurance, etc. So when two companies become one under product extension, they're able to gain access to a larger group of consumers, and that's a larger market share. So if I merge with this company, I'll also have access to people who want to buy, car insurance, health insurance, homeowners insurance. And now they're going to have access to space travelers, insurance for people who want to travel to outer space. Everything okay so far? Everybody getting that? Any questions?
No questions so far, but if anyone has got any questions, please write them. We love the questions.
Okay, let's see. I am in the process of looking through my notes because I am... All right, a market extension merger. This type of mergers occurs between companies that sell the same products but compete in different markets. Companies that engage in a market extension merger seek to gain access to bigger market and thus a bigger client base. Example, JLM Bank has a large presence in the southern part of the US, but not in the Northeast. It merges with NOP, a bank in the Northeast, to gain access to a bigger market. So you want a bigger market. You know what I mean? You have this bank, you want more people to see you, you want more people to know you. A horizontal merger occurs between companies operating in the same industry. Okay, the merger is typically a consolidation between two or more competitive offerings, offering the same product or services. Such mergers are common in industries with fewer firms, and the goal is to create a larger business with greater market share and economies of scale, since competition among fewer companies tends to be higher. Economy of scale, a proportionate saving in cost gained by an increased level of production. So I'm going to give you an example. Example, 1998 merger. The 1998 merger of Daimler-Benz and Chrysler is considered a horizontal merger. These two companies, they manufacture and sell cars. So they figured if they got together, okay, they'd reach a larger base. But in terms of production and in terms of price, it would be cheaper to produce, basically, because you have one firm now, you have one company producing both cars.
Ну, типа завтра приехать, да?
A vertical merger. A vertical merger is the merger of two or more companies that provide different supply chain functions for a common good or service. An example is company A is manufacturer of handbags and company B supplies the leather that is used to make these handbags. So it's vertical. So I make handbags, so I'm going to merge with a company that I make handbags. I'm going to merge with a company that supplies leather. That way, I don't have to go to a supplier to make the handbags. And what? It becomes cheaper. If it becomes cheaper, then what? More profit. Okay, an example. AD Champagne Company wants to expand its market base. Most people in the northeastern part of the U.S. has heard of it. However, it wants most of the people in the United States to know who they are. While at a business meeting, someone suggests to the owner of ADC that they should merge with another company. You are ADC's attorney. Which type of merger would you suggest, if any? Is a merger the proper avenue for brand and name expansion? If so, why? So this is a general question. So, and it might take a while. So I'll give you a couple of minutes.
Yeah. So everyone, so we have a hypothetical information.
And technically, I'm asking you for legal advice here. There's no right or wrong answer. I just want to see that you guys understand the concept.
Давай, приеду.
Okay, everyone, thank you very much. So we have some technical issues. Thank you very much for writing. And we will just ask our so while everyone is having some time to read, we will fix this technical issue. We have some third party talking through a microphone. So Alexandra will fix it. I cannot hear, but I will write now to our technician and I will ask him to fix him. Thank you, Lilia. Thank you, Marusia. So we'll deal with it. Okay. Okay, so we will ask. Thank you, everyone. So, and you focus on the hypo, okay? We'll fix it in a second. So there is Dmitry, who says that it's market extension merger. Pavel says that it is a horizontal merger.
Okay. Now, market extension and horizontal. Why is it proper for why do you want to use that particular type of merger? Is it a proper avenue for brand and name expansion, horizontal, or whatever the other one that was mentioned? Why do you want to use this particular merger? There are three others. Why, or four others. Why do you want to use that one? Tell me. Or anyone could chime in.
So Marusi says that it's to get a bigger client base.
Okay. It's to get a bigger...
And,
okay,
also,
so which one is to get a bigger client base? Which one? Like I said, horizontal. Somebody said horizontal and market extension.
Yeah,
okay.
Mostly everyone goes for market extension merger because the company needs to get a new market to increase market share, to increase your amount.
Okay, excellent. That's what I wanted to know. So you guys understand the concept. Okay, very good. Like I said, there was no right or wrong answer. I just kind of wanted to know if you guys understood the concept and how to apply them. So acquisition. So we're done with mergers now. We're going to go into acquisition. So remember, a merger, A plus B equals C. So now an acquisition is a financial transaction where one company purchases most of another company's shares to gain control of that company. So usually in an acquisition, they'll try to get at least 51% or more of the shares. If they get 51% more of the shares, that's the value of the company. Remember, we did shares before. Then they acquire the company becomes theirs. A firm buys more than 50% of a target company's shares. It effectively gains control of that company. An acquisition is often friendly, while a takeover can be hostile. Acquisitions are carried off with the help of an investment bank, as they are complex arrangements with legal and tax ramifications. Or even a merger mergers have legal and tax ramifications also, but an acquisition is completely different, because what you're doing is it's instead of A plus B equals C, now it's A plus B is A. Okay, it's not a new company. It's like having another child. You're bringing another child into the family. Acquisitions are usually friendly endeavors. They occur when the target firm agrees to be acquired, which means its board of directors approves the deal. Friendly acquisitions often work towards the mutual benefit of the acquiring and target companies. So it's going to benefit both companies. So, and they're usually friendly. Reasons for acquisitions: entering a new or foreign market, growth strategy, reducing excess capacity and decreasing competition, gaining new technology. This is something that was new to me. Sometimes it can be more cost efficient for a company to purchase another company that already has implemented a new technology successfully than to spend the time and money to develop a new technology itself. So say, for instance, you have a company, you have, let's say, 2 car companies. I'm going to say Honda and Toyota, okay? And Toyota has already knows how to use AI to produce cars. This is an example.
Mm-hmm.
So instead of Honda trying to go out and find the technology and hire people to do the same thing or trying to buy the technology, they said, look, we're both car people. We want to make our shareholders happy. You know, let's see if I can acquire the bigger company usually acquires a smaller company. Sometimes they go out, I'm going to acquire this company, and therefore I could use their technology, and I won't, I'll enter a new market, I'll grow, and I can get the benefits of a new technology without having to go through the process of creating one myself. Like I said,
Thank
the technology, huh?
Yes, and we have some comments that there is sometimes hostile acquisitions. So,
yeah, we're going to talk about that. We're going to get to that. Yeah.
Okay, Alexei will get about this.
Yeah. All right. So I'm just catching up with my slides now. Okay. All right.
And everyone just wanted to say that we're trying to fix this issue. If there is still someone talking, please, can you please write? Because from our side now, everything is clear. But if it continues, please go on. Alexander, there is someone interfering into your speech, but we're trying to fix it. Okay.
Okay, great. Okay. An acquisition generally describes a primary amicable transaction where both firms cooperate. A takeover, on the other hand, suggests that the target company resists or strongly opposes the purchase. And the term merger, as we said, is used when the purchasing and target companies mutually combine to form a completely new entity. Okay. So, but I'm going to get over to takeover. I'm going to go over takeovers big time. Okay. Acquisitions are primarily a financial transaction and are often friendly. True or false? Let's go, guys.
Mm-hmm. So again, you can see the question. So you can join Vivox if you want to vote anonymously. So, and so no one can see, or you can write your answer in the chat box. So on YouTube. Thank you, Elena, for writing. So everything is fine now with the view. So, okay. So, and there is a question you can see up on the screen. So, and we can see someone else joining. So to join Vivox, you can see the information in the top right corner, vivox.app, and then the number of ID. And we have some answers from Pavel and Nikita. It's very nice to see the familiar faces, well, familiar names. So they say it's true. And let us see what's in Vivox, Alexandra.
Yeah. True. Okay. So 12%. Okay. Yeah. So it's true. So acquisitions are financial. It's a financial. Remember, and they say it's a financial. It's not legal because you're buying out somebody's stock, somebody's ownership. Okay. That's where the finance comes in. Okay. There are legal ramifications to it. There are laws that you have to follow, but it's a financial transaction. And like I said, it's often friendly. Often. Very good. Okay, so types of acquisitions: vertical, horizontal, conglomerate, and co-generic. A vertical acquisition. The parent company acquires a company that is somewhere along its supply chain, either upstream, such as vendor supplier, or downstream, processor or retailer, okay? For example, McDonald's acquires a dairy farm for its cheese and milk products, okay? So it acquires a farm, therefore it doesn't have to go outside, you know, for its milk products, its cheese and milk products, its dairy product, okay? For its dairy products. Horizontal acquisition. Okay, the parent company buys a competitor or other firm in their own industry sector and at the same point in the supply chain, okay? Example, McDonald's buys a Burger King. I don't know if are there, first of all, are there McDonald's in Russia?
Oh, yes. Well, Right now, there is a different name of it, but we had McDonald's for many, many, many years.
Did you also have Burger King?
Oh, yes. We don't have Taco Bell, but we have KFC, Burger King, all of them.
You have them. Okay. So McDonald's buys Burger King. You know what I mean? That's a horizontal, you know? And the same point in the supply chain. Yeah. Conglomerate acquisition. The parent company buys a company in a different industry or sector entirely in a peripheral or unrelated business. McDonald's buys a small Southern bank. Okay. So McDonald's decides to go and get into a small Southern bank. And that happens a lot. I was looking up recently, a broadcasting company, a television company. And I was looking at all the companies that they have merged with, that they own, you know, either way. But a lot of them own restaurants, like restaurant chains. A lot of them own banks. So sometimes, you know, you thinking that you're working for Pepsi, but Pepsi owns banks and, you know, other kinds of restaurants. They own private equity firms. So do your research. And I say do your research because if you're working with a company and that company has a lot of other companies that it's affiliated with, that it has merged with, or it has acquired, it's under one company name. If something happens with that, if you're working for that prime company and you want to work for one of its subsidiaries, for instance, that may be a problem. So you have to know exactly who you're dealing with. Very, very, very important these days. Okay, a congeneric acquisition, also known as a market expansion. This occurs when the parent buys a firm that is in the same or closely related industry, but which has different business lines or products. McDonald's buys a company that franchises fried chicken, like Kentucky Fried Chicken. So say McDonald's buys Kentucky Fried Chicken. That's a congeneric acquisition, okay? It's expanding its market. It's a closely related industry. That means it's still fast food, but it's a totally different business. Burgers and chicken are totally different. Hypo, okay, baby care, children's wear, a children's clothing store wants to increase their profit and make their shareholders happy. As their attorney, what kind of acquisition would you suggest and why? And why is very, very important, guys.
No, that's a big story. That's a big question. So
I got to make sure that you guys understand the concepts, though.
Okay, everyone. So, okay. We have an interesting hypo. Someone would write. So that would be great. So, and we actually start getting some answers already. So Yelena says that the last one. So Marusia says horizontal, to be able to offer a wider range of products. Pavel says horizontal and the last one. So we do have some
last
answers.
one, which is what? Congeneric?
Oh, yes, this is horrible word. So for us to remember, but we will try. Congeneric. Mm-hmm. Yeah, I think it was the last one. Yeah. Congeneric. Yes. Mm-hmm.
And again, tell me why. Tell me why would it be congeneric? Why would you suggest that to me?
Yes, Marusia already answered. So she, and I can read her answer. So to be able to offer a wider range of products.
Okay.
Mm-hmm.
Okay, so to be able to, why would anyone suggest that I acquire another children's wear company?
Something like this. And Yelena says expansion. The idea is expansion. Okay. Daria says the same industry. So
yeah, so expansion in the same industry. So it could go either way. It depends on what my shareholders want. It depends on what the board wants. You know, that member of the shareholders are very, very important because they basically own the company.
And what's interesting is that, and kind of two more comments. Alexei says all the types, and Lydia says that as an example to buy a chain of kindergartens. So the preschooler.
That's an excellent one. Okay, first of all, that was excellent. To buy the kindergarten compared to the school, that would be really, really good. That makes a lot of sense. And then what you can do is you could tell the kindergartens that they have to wear certain uniforms, and then you produce the uniforms. That makes a lot of sense. The other one, it said all of them. You have to, and the problem that I have with all of them, there's a reason why they're all different. Everybody has a different need. Everybody has a different, they have a different need. Everybody has a different goal. Everyone has different strategies. So say, for instance, you're a lawyer, or you're hired as a lawyer, your baby care's lawyer, and then was like, I think I want to acquire another company, whatever. And you say, well, we can go all, here are your 5 choices, you decide, or we can do. No, but you, as a lawyer, you have to be specific. You have to know the company to know how it's gonna increase their profit and make their shareholders happy. What is it? How is it going to increase the profits more? The school one was an excellent one, trying to buy a group of kindergartens. That's really, really good. That was very, very good. But you have to be able to be specific, guys. You can't just say, oh, I'll look it up and we'll do any one of them. No, maybe all of them, not all of them may be, specific to baby care's needs. So you have to be very, very specific as an attorney. You have to know this very, very well. Okay? Takeover or hostile takeover. It's the same thing. A takeover or a hostile takeover is the same thing. The term hostile takeover refers to the acquisition of one company by another corporation against the wishes of the former. The company being acquired in a hostile takeover is called the target company, while the one executing the takeover is called the acquirer. So a lot of times, some companies, especially smaller companies, they don't like to be taken over. They like being small. You know what I mean? That's their thing, or they want an opportunity to grow. The acquirer, on the other hand, sees an opportunity for growth. And if the acquirer can buy the stocks of that target company, then game over. They own it.
Yes.
An acquiring company can achieve a hostile takeover by going directly to the target company's shareholders or fighting to replace its management. That's one way, okay? So they go to the shareholders and say, look, you know what I mean? We want to make this good for you. So which shareholder, they want more dividends. They want more money. So, most shareholders say, okay, I bought into this particular company because I want more, it's an investment. I want this investment to make money. Therefore, you know what I mean? If the acquiring company is gonna, if this company is gonna acquire us and it's gonna give me more money, yay. Okay. Hostile takeovers may take place if a company believes the target is undervalued or when activist shareholders want changes in a company. Okay, so say for instance, I own, again, my champagne company. I own a worldwide champagne company. Okay, and there's a company that is producing wine, and they say that this company is worth $30 million. But I know the industry better. I know that based on my research, this company is worth 50 or 60 million. Okay. So if I buy it, acquire all the shares, what's going to happen? I'm going to get it at a really, really inexpensive price. And then I'm going to get all the profits. Okay. So again, it's hostile because what? The wine company may not want to sell. Okay. Or shareholders want changes in the company. Sometimes you have a company that, okay, let's give the example of the wine company. Say, for instance, the wine company is creating a lot of pollution. The wine company isn't following government regulations. Okay. They're not doing, their due diligence. They're not doing what they're supposed to be doing. They're not doing they're not doing their ethical obligations, providing their ethical obligations. Okay, so the shareholders want change. So they go to the board and the shareholders say, look, you got to change this. You know what I mean? What if this company takes over? You know what I mean? They have a better track record, of their ethical and financial, their ethics and their finances. They have excellent track records. It'll be better for us. Okay, a tender offer and a proxy fight are two methods in achieving a hostile takeover. So a tender offer, and I'll give the proxy fight later. I'll explain those later. But target companies can use certain defenses, such as the poison pill or the golden parachute, to ward off hostile takeovers. Okay, a tender offer and a proxy fight are two methods of achieving a proxy fight. So, does anybody remember what a proxy is, or a tender offer from when we were talking about corporations?
So we can ask for
Okay.
the answer. So so everyone, the question, and I have a question from the audience. So while you're answering, we can wait for the answer. So and if someone remembers what is a tender offer and the proxy fight, and while we're waiting for the answers, there are answers. There is Daria with her question about she asks, is it correct that for mergers, the law differentiates between congeneric and market expansions mergers, and for acquisition, these terms mean the same type of acquisition?
Okay. So one thing that I wanted to stress again, for acquisitions, remember, it's not a legal, it's a financial. So you're dealing with money, exchanging money more so than anything else. Okay. So that's very, very, very important. And in terms of, okay, could you repeat the question?
Yeah, so it's kind of specific. So is it correct that for mergers, the law differentiates between congeneric and market expansions mergers? And for acquisitions, these terms means the same type of acquisition.
Okay, so for acquisitions, congeneric and market expansion.
Market expansion, yeah. Yes. So
let me look through. I am going to look because I am going to see vertical, horizontal, conglomerate, and congeneric. Okay, because there is because there is no market expansion. Okay. All right.
Maybe we just didn't conclude it. That is
okay.
all.
Okay. And I know because there are only 4 for acquisitions and 5 for
yeah, that's why there was maybe a misunderstanding or something.
It wasn't a mistake. Okay, you can argue that a congeneric acquisition is basically the same as market expansion. You can argue that. Yeah, you can argue that. It's the same thing. But the thing is, it's just, remember, they're not, and that's why I wanted to explain. For market expansion, market expansion is a process, okay? Remember that. And what is a acquisition? It's a financial transaction as opposed to a process. Do you see what I'm saying? You see the difference?
Yes.
So that's probably why they don't have one for market expansion, because you're trying to, when you're acquiring a company, you're expanding your market anyway. So it would be redundant.
It's just excessive, yeah.
You see what I mean? Okay, so market expansion. If I'm acquiring a company, I'm acquiring a company to expand my market. That's it. I'm not doing anything else. You know what I mean? That's why mergers, you come together for different reasons, but that's why so it would kind of be redundant to have market expansion because it's already a market expansion.
It's already in there, sort of by default.
Yeah, the act itself is a market expansion. That's why they don't have a specific one. And yes, congeneric acquisition would be similar to a market expansion. Yeah.
Okay, thank you very much. And thank you very much. And thank you, Lena. And thank you, Alexandra, for answering the question. And we do have some answers for proxy. So first of all, speaking about the proxy, Daria, Pavel, Alexei, basically the same, that it's a kind of representative, a trusted person, somebody who acts on behalf of another person. And if speaking about tender offer, we have a suggestion that it's a sort of situation that I've made someone at the proposal that this person could not reject, sort of like this.
Yeah. So a hostile go, proxy or whatever. I could, I'm going to make you an offer that you can't reject. Here, we're talking to shareholders or whatever. You own 30%, at $1 million. I'll buy you 30% for $120 million. Okay. And proxy is basically, like you said, you're standing in for somebody else. So you go in and you argue for the shareholder. You know what I mean? Well, I'm standing in, so-and-so gave me a proxy. And instead of the shareholder speaking, then the person who wants to acquire speaks and gives all the reasons to the shareholders and the board why this would be advantageous to them. So that's a tender offer and proxy fight. Okay. That's when the acquiring company wants to be slick. So, say they buy other people's stock, or they represent other people and say, I'm representing so-and-so gave me the permission to say that this would be the best, the best financial transaction for this particular company.
Alexandra, can we ask, yes, just one more thing about the poison pill, because we had some excitement in the comments about this very interesting phrase. Golden parachute, we understand, but poison pill is something very specific.
Okay, hold on, wait a minute.
Yeah, there is like, on the previous page.
No, I know. I'm gonna do poison pill after I do golden parachute.
Super, thank you.
Okay, so golden parachute, substantial benefits are given to a top executive. The company is taken over by another firm. The executives are terminated as a result of the merger or takeover or acquisition. Example, and this is true, Meg Whitman, Chief Executive Officer of Hewlett-Packard Enterprise, stood to receive $91 million if a company was acquired under her control. She was also promised more than $51 million in compensation if she was terminated. So you see the golden parachute? You know what I mean? Okay.
That's very golden.
Yes. So say, for instance, we take over, we acquire, and we decide, you know what? You're not the best CEO for us. We'll give you a $51 million. And the $51 million is just cash, okay? There's also stock options, also health insurance. If it's a company like, Hewlett-Packard, she may be able to get Hewlett-Packard, and her family members may be able to get Hewlett-Packard printers or whatever products at a discounted price. So they make it very, very, very sweet. But in the meantime, if we don't fire you and you do stay, we're going to give you $91 million. Okay. So then what would Meg Whitman do? Meg Whitman would go to the board of directors if she has a good relationship with them, and would try to convince the board this would be the best thing for our company. You know what I mean? This would be the best thing for our company. So please vote as the board to, to allow them to acquire, and then we can tell the shareholders, et cetera, et cetera, et cetera. Yeah. So that is the golden parachute. Poison pill is designed to discourage a major acquisition of the shares in a company's hostile takeover by an individual entity. Once activated, the strategy allows shareholders, with the exception of the acquiring party, to buy additional shares of a company stock at a highly discounted price. Okay, so what did I say? An acquisition is what? The acquiring company buys a majority of the stock, right? Of the majority of the shares. They need at least 51%. At least 51%. So you have news that somebody wants to acquire your company. There are rumors. These rumors, there are always rumors. People are always talking. So what do? Well, you want to keep it. So you have shareholders, your shareholders, buy additional shares of the stock at a discounted price. That way, you have the majority of the shares. They don't get the 51% that they need to acquire the company. So that's the poison pill. Any questions concerning the parachute or the poison pill?
I think poison pill is kind of specific, but we'll wait.
Okay.
So basically, everyone says no questions. It's kind of understandable. So,
Okay.
And Alexei says that there is a comment that in Russia for protection, we use loans and mortgage, as I understand, in such situation.
Okay, well, what do you mean by loans and mortgage in terms of where? What do you mean?
Yes, so Alexei, I think you will need to clarify your comment, which is quite interesting. So for protection of the company, or like if you can write in more details, we can go further because it takes time. So, and then we'll get back to it, I suggest. So, because it's, okay. So Alexei says that big debt means big problem. So maybe on purpose to put the company into big debt, so the other company would not want to buy it.
So we're gonna discuss that with due diligence, which is next. So due diligence is like a lot of information. So we're gonna talk about that.
Mm-hmm.
Okay. So due diligence, pages 42 to 64. So when you're going over, know that pages 42 to 64 all have to do with due diligence. Okay, M&A due diligence. Okay, due diligence, reasonable steps taken by a person in order to satisfy legal requirement, especially in buying or selling something. Okay, so Every day I do my due diligence. I'm more of a compliance person, more than a legal role. I'm more in a, so what I do my due diligence. I make sure that if we're going to give a particular vendor money, that they satisfy certain requirements. That's the due diligence. Okay. So the first thing, you go to the seller entity. So seller is the person that you're acquiring, or the seller is the person that you're merging with. Okay. So you go to their organization, governance, and good standing. You look at their organization, their governance, and good standing. What does that entail? You go to their articles of organization, their bylaws, their operating agreements, their shareholder agreements. Okay. You identify, and these things, and again, let me start by saying it, and I should have said it when we began. These are transactions. So a lot of times lawyers don't necessarily do all of this. A lot of times, excuse me, it's the bank that does this, because there's a lot of money involved in this. Okay. So a lot of times you have lawyers who do some of the work, but they work very, very closely with the finance people to make sure all of this is in order. Okay. Second, you identify shareholders, directors, and officers. Okay. And minute books. Why is it important to identify shareholders, directors, and officers? And does everyone know what a minute book is?
Mm-hmm. So we can just wait for the answers.
Yeah.
Mm-hmm. And you call it minute, not minutes. Yes.
Minute books. Yeah. Minute. Yeah.
Mm-hmm. Okay. That is quite interesting. So, but we'll need to give some time, because so it's Yelena says that it's a base for entity. Pavel says that to avoid AML risks. So everyone answers.
Basically you identify the shareholders, directors, and officers because you want to know who you're dealing with. Exactly. Mm-hmm. You want to identify them. You want to know exactly who they're dealing with. If there are any issues with them, if they're on the up and up, have they continued, have they done any elite? That's what the directors and officers. Are there in any trouble? Are there any trouble that could affect the company that you're merging with, or the company that you're acquiring, etc.? Shareholders, you want to know how many and how much money they've invested in the company. Okay. Minute books. Okay. A minute book is every time there's a meeting, a board meeting, minutes are taken, and minutes are exactly what is said during the board meeting. Okay. So every meeting, I don't know if you guys do this. Every time I
yes.
You take notes, and then at the end you send the minutes to the board members, and it's kept in a book as proof. If the state wants to audit you as proof that there was a meeting, because some places you have to have at least 3 or 4 annual meetings. Okay. Minute books are important. So based on what I've told you, why are minute books important as due diligence? Why would you, if you're acquiring a company or if you're merging with a company, why would the minute books be important?
So everyone will have a lot of questions today. So why would a minutes book be important? And yes, so we have answers from our audience. We're speaking in general about the minutes book, that it's the minutes of board, shareholders meeting, records of meetings of the board and directors. In Russia, we'll very often call it protocol. So of the meetings, a lot of people, that's why confuse it. Marusia says that you need minute books because you want to know the state of the business, what's going on. We need to know all, and we need to record agreements and decisions. And Yelena says that it's like KGB notes of a company. So that's exactly what is being said.
Exactly. So you want to know the mindset of the board. What is the board thinking? What were they doing? Sometimes boards do things you don't know. So the minute books provide the answer. So it's very, very important that you get that information. Communication with shareholders. What were the shareholders told? You know what I mean? Were the shareholders told that, the company was making, $10 million per quarter, and in actuality, they were only making 5? What were the shareholders told? List of businesses and names and business locations. If you're merging with an entity, you want to know if they own other entities also, and the names of those entities and their locations. Also, if you're acquiring them. So if you're merging with Pepsi and Pepsi owns movie theaters and banks, you want to know the names of all those banks and all those movie theaters. Okay, so you see how complicated it can get? Issued and applied permits and business licenses. Okay, are you operating under the law? You know, do you have a business license? And these are for all the companies. So say, for instance, that's like I said, this is very due diligence. It's all about due diligence. Say, for instance, I gave you Pepsi. Pepsi owns, you know, an art gallery. Let's just say that, okay? Does the art gallery have all the business permits and licenses it needs? And this is for the USA and international. So imagine if you're merging with a company and that company has other subsidiaries, you have to get the information for all of its subsidiaries. So you see how complicated and long this can take? It's a really, really complex. It's like, it's all about due diligence. It's a really, really, really long and complex transaction. You look at their corporate policies and their procedures. That's pretty straightforward. Capitalization tables details who owns the company. You have information concerning the name, how much they own, and what is the percentage of the ownership. So you have to know everyone who owns shares. You have to have a list of that. So you know who owns what. Outstanding shares. Are there outstanding shares? Convertible securities, options, and warrant. Where is the money? You know, is there money? Is there money to be made? Can we sell? You know what I mean? Where do we have our money? Okay, dividend distribution policies. How often do you distribute dividends? Once a month, every 3 months, every 6 months? Okay, voting agreements. A voting agreement is a contract in which shareholder agrees to vote a certain way on specific issues without giving up their shares or voting rights. Okay, are there certain voting agreements? Okay, and you know, if you have a voting agreement and that voting agreement is against your corporate policies, you have to know that, and you have to be able to change that, and you have to be able to notify the shareholders that, you know, some of you have voting agreements on these specific topics. We're not going to honor them. Okay. Transfer restrictions. Are certain restrictions, are certain transfers restricted? Transfer of debt, transfer of money, transfer of securities, whatever. Are there restrictions? Very, very important.
And we have one question related to the previous slide. Elena asks if you could clarify, what does it mean, operating agreement?
An operating agreement, how you do business. You know what I mean? So we're McDonald's, we do business. We have, you know, this is how we operate. We have the people in the front taking orders. We have people in the back cooking it. And we have some guy bringing the order to you. That's your operating agreement.
Okay.
How you operate. Okay. So, and that's important. And why would you think that's important to know? Let me ask you that. And I'm asking a lot of questions because these are just a lot of facts that I'm giving you. So I want you guys to know that, you know, I want you to be engaged in this. So why would an operating agreement be important?
So, and while we wait for the answer, we can just give them some time because it takes time to digest. Okay. So, So, and we can maybe speak about the next slide and then we'll get back. So maybe, Yelena, it's a question for you. Why would be it important, the process? Yes.
Yeah, the process. Okay. Preemptive rights. Purchase newly issued stock before offered to others. Are there preemptive rights? Maybe you don't want to do that because remember, preemptive rights is, you know, newly issued stocks get offered to others or a certain group of people. Maybe you don't want that certain group of people to get the stock. Maybe you don't want to do that anymore. Consent requirements. Proof that powers that be consent to a merger and acquisition. Okay. So, you know, was there consent? Did the board consent? Did the CEO consent? Who didn't consent? And the people who didn't consent, maybe we don't want them around. You know what I mean? Related party transactions. You know what I mean? Are there any transactions that are similar? You know what I mean? Are there mergers that were similar? You know, if this company that we're merging or acquiring, if they had other mergers or there were, you know, acquisitions, are they similar to ours? How are they similar? Merger or reorganization agreements. Okay. Again, if the other company merged or they acquired or they acquired or they were acquired, reorganization agreements. Who does what? Who's in charge of what? You know, you need to know who's in charge of what, where everything goes, who has the licenses, et cetera, et cetera. Okay. Somebody about the operationing.
Yes, and we do have the answers. Sorry. So about the operating agreements, why they are important. Elena says because it explains each step of the business. Pavel says that it shows the profile and activities of the company as a whole, and Daria says that it shows day-to-day operations of the company.
Yeah, exactly. So you want to know what you're doing. So I'm pretty sure. Let's remember I gave you the example of McDonald's and Kentucky Fried Chicken. Okay, so burgers and chicken are cooked the same way. So you have to know, okay, well, they cook the burgers this way and we cook our chicken this way. Okay, how are we going to make this work? Are we going to leave them the way they're doing it? Or are we going to try to implement some of our practices? So that's why. Okay, or another reason, okay, they're operating this way, but they're losing money. Okay, so if they're losing money, if they're operating one way and they're losing money, maybe we should change their operating methods. Okay, so that's why operating agreements are important. Okay, we're merging and acquiring. What do you think will happen to the leadership team? So two companies, one company acquires another company or they merge. What's going to happen to the leadership team, the managers and everything, even the workers? What do you think happens?
So... And while we're waiting for the answer, so which you can see the question up on the screen, we have a question from the audience to you, Alexandra. So are there any due diligence checklists for different types of companies, if you are aware of it, sort of?
No, okay. I look, this is the general, I'm giving you the general information here. Okay, so let's just say, okay, I'm pretty sure that the due diligence checklist for a financial institution is going to be different from one of a restaurant. Why? Because they're different industries. So you have to look for different things. Remember, due diligence, you're looking for different things. Right? So, you know, like I said, an operating, maybe for the chicken, the restaurant, maybe an operating agreement is more important than in that industry than it is for a bank, because you basically know how a bank operates. You see what I'm saying? So it depends on the industry. Every industry probably has different due diligence checklist simply because the industry is different. Okay, so as I said, if you're making hamburgers and you're making chicken, those are two different products. So you're probably going to have to check what? Well, you know what I mean? Are the chickens healthy? Where do you get the chickens? You know what I mean? Did the government approve where you got the chickens? You know what I mean? There may be a totally different government regulations, et cetera, for beef and potatoes. Okay, so it depends, but I'm giving you the general checklist right now.
Thank you very much. And we do have some answers about the question. So, well, Alexei is very straightforward. He says they're going to be fired. So Marusia says someone will stay, some might be let go. Daria says, as very legal answer, lawyerish, it depends, needs to be decided by way of negotiation. Pavel says leadership team may remain or they may be changed. So someone says that it depends on the articles of his organization, the amount of workers may be cut down, and they all may be fired. So
all of you are correct. So it depends. But usually what happens is the person the company that's merged with the other company, the bigger company usually runs everything, and the other people are usually let go. So you know what I mean? You can't have two legal departments. You can't have two finance departments. So if a person is usually very, very good, one person may stay or so, but usually the bulk of the people are let go, especially like the VPs, the vice presidents, senior vice presidents. They're usually let go. They're usually the first ones to let go. And as the company comes together, they merge and start working together, then they need to see where there's an overlap. And where there's an overlap, that's when they start letting the people go. Yeah. So both everything, usually you're very, very right. Yeah. Because you think about it, you know, as I said, you don't need two legal teams, you don't need two accounting teams, you don't need them. So some people have to be fired. So you're also looking at the company's subsidiaries, affiliates, and joint ventures, okay? Entity organization chart and description of all related entities. As I said, if you're acquiring a company that has acquired or merged with other companies, you have to get this information for all of their companies. Gather the information listed above for all related entities, as I said. Yep. The seller financial information. So we're talking about the seller entity, what makes the organization. Now we're talking about their finances. So you look at their assets and operations, their financial statements and projections. Remember those. Sales and revenue, cost analysis, balance sheets. Remember that in the beginning. Budgets, cash flow, debt schedule, loan financing and security agreements, payments and defaults, bankruptcy or insolvency, auditor reports. Very important. You have to know what financial state they're in. Okay. So bankruptcy or insolvency, you know what I mean? Okay. If we're looking through your stuff and you're insolvent, you can't currently pay your debt and you're bankrupt right now, we have to deal with that. Okay. The auditor reports. What do the auditor reports say? You may be telling us, oh, no, we're a solid company or whatever. And the auditor reports say something completely different. So all of this has to be read and analyzed and assessed. Okay. Internal control, operations and assets and operations continued, internal control procedures, bank and investment accounts, owned and leased real estate. Very, very important. You know what I mean? If we own the buildings that we operate in, if we own the buildings that we operate in, as opposed to leasing them, okay, we're ownership. How do we pay? Are they fully paid? If they're leased, what do the leases say? How long do we have on the leases? So if I'm buying a company or I'm merging with a company or acquiring a company and they're leasing their real estate, their corporate headquarters are leased, how long do they have on the lease? Okay, so as soon as this merger is done, do I have to go and renegotiate the lease? So that's important things. These are important things that you need to know. Inventory, valuations. How much inventory do you have? What is the value of the inventory? If you're manufacturing, huh?
Well, yes, sometimes some people might not understand the word inventory, like stock, how many goods you have like in stock.
Oh, I'm sorry. Okay, yeah, inventory is
no, it's okay.
Yeah, and what is that inventory, the stock, the merchandise that you have, what is its value? Okay, so say for instance, again, we're going to go back to restaurants because it's easier. Okay, we have, 10 blocks or a million blocks of cheese. Okay. All right. So we have a million blocks of cheese to make cheeseburgers. Okay. That's how much, what's the value of it? And is that value by the time this merger or acquisition is complete? What's going to be the value? Will it decrease? Can we hold on to it, etc.? Okay. So when you're manufacturing, owned and outsourced, do you own the manufacturing plant? You know what I mean? So if you're manufacturing, say you're making scarves and gloves and hats, okay? Are you owning it? Is the manufacturer, are you the manufacturer? Is the company the manufacturer? Or are you outsourcing it? Are you giving it to another company to create the scarves and the hats? That makes a big difference too, because that's money. So you got to look at the sites, the products produced, the capacity. If you own it, you got to look at the site. What does the site have? Again, how are they producing these things? What are they producing? The capacity. So say, for instance, I say hats, gloves, and scarves. Okay, well, this site, I own it, and I'm only producing hats and gloves. But the other site is outsourced, and they're doing they're doing something else for us. Okay, well, can we stop the outsourcing and have everything manufactured within the site that we own? Questions that need to be asked. Equipment and other tangible assets. Intangible assets, including goodwill, customer list, software, intellectual property rights. When I say goodwill, what do I mean? Does anybody know?
That's actually exactly the question that is being asked now on YouTube. I was waiting for a chance to ask it. What is goodwill on this slide?
Like say, for instance, a lot of companies partner with a lot of charities and give charities a lot of money. Or they give charities money, or they give charities time. They offer a lot of corporate people, they offer their employees to do volunteer work. That's goodwill. Okay. So when you think about goodwill, think about charities, think about, making donations. That's goodwill. And many times, if a company is doing a lot of goodwill, what they would do, one of their subsidiaries would be, and we're going to talk about nonprofits next week, one of their subsidiaries would be a nonprofit organization that would take care of the goodwill. So, and that's important. You need to know if you have nonprofit organizations, because nonprofit law is totally different from regular corporate law. Okay, taxes. That's important. Identify all locations where taxes are paid. You have to know where you pay taxes. In the United States, they don't play when it comes to paying taxes. You will get interest. They will take your property. They will seize your property if you do not pay your taxes. Very important. State, federal, international tax returns, payroll taxes, sale taxes, withholding, and FICA. So FICA is basically insurance, Social Security, and insurance for your employees. So that's very, very important. You have to know that. Accruals, how much tax have you accrued? Okay, some companies pay their taxes quarterly. Okay, how much taxes do you accrue quarterly? You know what I mean? Do you pay the feds or the state or the local taxes? You give them what? 1 million to the feds, 50,000 to the state. So you have to know how taxes are accrued and and make sure that they are paying the insurance and the Social Security for your employees. That's very, very important. A lot of people get into trouble for that. And a lot of people don't want to do that. That's why they call people independent contractors. We had that conversation last week. So yeah, because they don't want to pay the taxes. They don't want to pay it. So you're in charge of that. All right, correspondence with taxing authorities. That's very important. Again, you're telling me that you paid all your taxes, but the IRS is telling me something completely different. Contracts and commitments, commercial contracts. These are the kinds of things you look at: purchase or sale of substantial assets, distributor, franchise, supply agreements, sales agreements, customer agreements, electronic marketplace agreements, research and development, leases. We talked about leases before. Okay, that's a rental agreement. IT support, telecommunications, web development, data processing and storage, cloud computing, marketing and advertising. These are all the things that you have to look over.
Now, Alexandra, I understand why you said that it's not an exciting topic.
It's not an exciting topic.
It's horrible.
It's due diligence. Remember, it's all about due diligence. It's all about due diligence. Suppliers or customers outside the USA, current form agreements, IT, data processing. We did that. Suppliers or customers outside the USA. Sales and purchase orders. This is all the things that you have to do. This is all. So mergers and acquisitions is all due diligence. That's all it is. That's all it is. You're coming together. You're saying, okay, I want to buy you, but this is all the things that I have to do. Okay. And you have the issue of, if you do all of this and you get it together, and then the Federal Trade Commission says to you, you know what? You're going to take too much of the market. We're not going to let this go through. So can you imagine? Okay.
And you've spent like a year researching all of this.
You can spend 2 years. Yeah, you can spend 2 years. And imagine this. Okay. You decide you're going to merge. Okay. You have to tell the FTC. Okay. So before you get the go-ahead, the FTC has to do research too. So that could take 6 months to a year. Okay. Then if you don't agree with them, then you can challenge it. Okay. That's a lawsuit. Okay. Let's say that's another year and a half. And then after that, if they give you the go-ahead, then you have to go through all of this. Okay. So it's a process. Like I said, it's not exciting. It's a process. It's due diligence. It's a process. Okay. Business protection and restrictions. Non-competition, non-disclosure forms, indemnity agreements. One party agrees to pay for the other for loss. Guarantees, formal promises, usually to pay a debt. Important. Finance. We're almost through this. This is important. This is something that I want to know. What are the constructs of a merger and or acquisition in Russia, if any? In other words, are they as detailed as the process we're currently discussing?
And constructs, which
the formation, the formation.
Formation.
Yeah.
So, okay, everyone. So while we're waiting for the answers, there are a couple of questions we have. So from the audience. So one of them was, for example, well, it's very lawyerish question. So why are software and intellectual property rights were divided into two different categories? So usually,
it depends if you own it, if you own it, or if you outsource it. Ownership is one thing. Outsourcing an agreement with another company is something totally different. So you have to know which one, and you have to act accordingly.
Okay, thank you very much. So, and everyone, just wanted to remind you that we're just waiting for the answer to the question. So, if someone wears are the mergers and acquisitions in Russia as dictate the process we just discussed or not? So, and well, there is quite interesting. We have one answer for now. Maybe we'll have more. So, and Pavel says that no, they are simple, sometimes without correct due diligence.
Okay. Let's wait for it because I'm going to have to ask another question about this.
Okay. So, and we might have some other answers, but we'll need just to wait because it might take time for someone to type. Oh, maybe. So we will not. So we'll see. So for now, no. And also speaking about goodwill. So very often in Russia, goodwill will be not always, but sometimes will be understood differently, meaning like our business reputation, like or reputation of the business, like goodwill. So it's a different story here.
Totally different. Goodwill, the reputation of your business comes with your ethics, comes with, in terms of ethics. We talked about that, your corporate ethics, your sustainability, your audits. That's your reputation. How much money you have, how you deal with other people, how you deal with the environment, how you deal within your community. When we're talking goodwill here is your charitable actions. How much money you give to charity, how much time you give to charity. Are you associated with any charities? So sometimes you have a company that says, okay, if we make cookies, for every 10 cookies we sell, we're going to give this particular charity, $3. Okay, so that's your goodwill.
And also there is also a third sort of way of how goodwill sometimes interpreted might be interpreted in Russia. It's like all intangible assets of business, not all like brand, how much it costs. Or like, so something like this. And very often I've seen it's very often it is translated like this, like business reputation. So that would be totally different. So, okay. So not so far an answer, but there is just a comment from Alexei that we do focus on ecological issues as well. But speaking about the detailed process, we've so far had only an answer from Pavel that maybe different story, that they may be simple, but not correct due diligence.
All right. So, okay. And this is one question. If the due diligence isn't as in depth, doesn't that cause trouble? Doesn't that cause problems?
Obviously, yeah. So, and Dmitry actually says that the general appearance is the same. So basically those who are like more into this, they say that's basically the same checklist sort of.
Okay.
Give it to take it.
Yeah, but it's taken very seriously. Like I said, a merger that could take years. Okay, government compliance with the law. We're going to continue. These are the things that you have to check. Communication with government and regulatory agencies. Consents and approvals to do business. Okay, government contracts. Government contracts are totally different than contracts with private industry. Very, very totally different animal. So you have to make sure you're on par with your government contracts. Inquiries, notice, reports, or correspondence with government. What is the government telling you? What did they tell you? Did they tell you that you did something wrong? Did they tell you that you had to change something? If you're doing import and export, restrictions or exemptions granted or denied. Okay. So if you're, a McDonald's and you want to export the 1,000 blocks of cheese that I taught, is that restricted? Or are you allowed to do it? And if you are doing it, you're doing it illegally, we have to stop it right away.
And just wanted to remind that we have like 5 minutes left.
Okay.
So...
Okay, we don't have much time. Okay, so I'm going to go for, some stuff. Regulatory compliance reports, studies on data. These are things that you need to know. Environmental stuff. If you're dealing with the environment, these are things that you need to know. Policies and other materials, document compliance, environmental and privacy. Privacy is very, very important in the US now. So privacy is a big one. Privacy and data security. These are all the things that you have to know. Security breaches. Have there been any data or security breaches or cyber attacks? Very important. Very, very important. This one is important too. Identify type of information collected in business purposes. That is an issue because if you're collecting information on people and it does nothing to do with your business, you may get in trouble for that. Intellectual property, your patents, your trademarks, your copyrights, your royalty agreements, who owns what. You go, very important. Legal opinions or common interest agreements related to any of the above. A legal opinion, what is, should we do this? Should we not do this? Okay. So software, operating system, databases, SaaS, these are all of the things. Litigation, all pending and threatened cases. Infringement actions, all pending and threatened cases are called infringement actions. Settle litigations and judgment, damages, payment schedules. You have to know who you owe. You have to know who you're going to go to court with. You have to know, I did research with a company last week that have 250 outstanding lawsuits. Okay, so who's doing
250, what? Like 250.
Yeah, 250 lawsuits. Was there, some companies have 400 lawsuits, depending on the company. Do you want to deal with a company, or you may one of the requirements? One of the terms of the merger may say, okay, before we merge or before I acquire you, you have to settle at least half of these. You know what I mean? You have to get them out of the way. Settle with the client. These are things you have to discuss. Okay. Products and services. What are you offering? Warranties. Okay. Recalls, warranties offered in contract, sales, literature, websites. What is a warranty? We guarantee that we're going to give you this. Okay. Maybe the company that's being merged or acquired wants to guarantee that they're going to give you this, but the company that's acquiring or merging the main company may not want to give it. That's something that has to be discussed. Okay. I'm trying to go as fast as I can. Top selling products. What are your top selling products? Largest customers, largest suppliers. You have to know that. Personnel benefits. And each one of these has at least 5 things under them. So I just went, personnel is very important. Personnel and policies, compensation, how much money people are making, benefits, stock options, health insurance, severance. Severance and health insurance is going to be very, very important if you're merging or acquiring, because remember, you're getting rid of people. So severance is how much money you owe people when you get rid of them, their insurance, or you're going to continue their health insurance. Workers' compensation, unemployment, collective bargaining when you're dealing with a union. And I could go on and on. Okay. So we've done all of this. Okay. We've done all of that. So you're finalizing the deal. So the deal is final. Okay. When the buyer has completed his due diligence and plans to move forward, he solicits final board approval. He goes to the board. We have done all of this. Here's the report. Everything seems to be in order. If we have problems, this is how we're going to fix it. Okay. You sign the agreement because it's a contract. Remember, we're buying you, or we're merging, we're acquiring you. Once you sign the final agreement, the deal is closed. You have either merged or you have been acquired by another company, and integration begins. Any questions? I'm like a minute. Like I have a minute.
Yeah.
So, and I didn't go through everything that I wanted to go through because there's some other things that I wanted to discuss about privacy, because privacy is really, really big right now for mergers and acquisitions, but I didn't have time. So any questions? I have time for one question, I think.
So actually, well, for now, no, I think everyone is just having looked at all of these deal things about why do lawyers go into mergers and acquisitions. It's just such a, you just look at it and you're already horrified. It's like an Everest. So for now, no questions.
Remember, lawyers and bankers are working on it. So you have a lot of people working on it. It's not only lawyers, but it's lawyers.
Of course.
Yeah. Okay.
Yeah.
All right, guys. Thank you. Like I told you it wasn't very exciting. I told you it was a process. And like I tell you, due diligence is a process. So we went through the process. Okay. And once the process is over, you know what kind of merger acquisition you want. You do your due diligence. You go through the process. You sign the agreement. FTC clears it, way before, then you're good to go. Okay.
I actually do have one question.
Sure.
Let's go. And then if someone else has something, we can answer next time. Do you have practice when a big company is divided into several smaller companies to decrease the amount of taxes? That's the big question at the end.
Okay. I mean, you have to understand, companies usually don't become smaller by will. Okay. in the United States. A company is not going to say, oh, we're going to become smaller to save on taxes. No. Okay. They have lobbyists, they have people who go to Congress, they have politicians, they have, you know, a lot of big companies have tax deals. They pay taxes, don't get me wrong, and they have to pay the taxes for the employee. That's a must. But they have deals with the, you know, with the state, the city that they're in. They have reduced taxes, etc. But no company is going to break itself up just to save taxes. Companies want to be bigger. They want to expand.
Okay, thank you. That was an excellent question. So, and if there are more questions, we will save them and we'll ask them next time, because we need to get going. And Alexandra actually needs to get back to work because it's the working day for her right now. It's 11 and 12, I think, daytime in New York right now. So, or at least it's already around 1 or something like this, 12:30. So thank you so much. And I'm giving you our thanks from everyone, because it was like such an in-depth insight into this very difficult, extremely difficult topic. So, and we're really very, very grateful. I just wanted to remind you, everyone, that we will have a presentation. All of the presentations are uploaded on our website. You can download them. So it will be there tomorrow. And there will be about 30-40 words translated from this presentation, which is also available for you. The links are on our official website. And we're approaching the end of our project. And in 2 weeks, we have our final webinar, number 6. And Alexandra, what's going to be the topic of it?
Not-for-profits.
Not-for-profits.
That's the major topic, not-for-profits. So we've dealt with profits, we've dealt with corporates. Now we're going to deal with nonprofit corporations, what they are, what they do, etc.
Okay, that's
a major topic.
That's a major topic. So we will see everyone. So, and just wanted to remind you that several days after our webinar number 6, we will have an online test. So that will be based on the presentations and on the webinars. And if you are a good student and you pass it, you will be able to get a free certificate from the American Bureau of Education. So, and it will be yours. So on a very, very specific and interesting topic. So thank you, everyone. Thank you. We say goodbye to you. And thank you so much, Alexandra. We'll see you in 2 weeks for the last time. Thank you so much. Yes. Bye. Bye, everyone. Goodbye. Goodbye. And thank you, our audience, for being with us.